court, and the court of final jurisdiction, a person can keep pounding and pounding the same matter, dragging the same person to court until they get a different result. The same court has told us you can't do that, but it has been done now. What are the odds that the court that decided in a matter 4 times, the 5th time, the 4 times they were wrong and the 5th time they are correct? What are the odds that this time around they are correct and they've been wrong all the 4 times? What is it that has changed over the years that has made the matter different? The only thing that has changed is that there have been new judges that have been put on the bench, and the Attorney General has changed. So positions, legal positions have changed with personalities. Is that what a legal system should be? We think not. So that and many other questions we'll have to address throughout this program.
We'll have to address a number of issues, Counsel, indeed, as we've said, but for now, in case you did not watch that live broadcast today at the Constitutional Court, it will be important for you to just have a snapshot of this clip of Honorable Justice Arnold Mwetwa Shilimi. Let's watch together and listen. Later on, Honorable Counsel Makebi Zulu will dive into the discussion.
And the repealed Article 35 of the Constitution is that the first respondent's term of office, that ran from 25th January 2015 to 13th September 2016, constituted a term of office. The first respondent's term, which ran from 13th September 2016 to August 2021, constituted his second term. The first respondent, Mr. Edgar Lungu, has therefore been twice elected and has twice held office. Article 106(3) of the Constitution makes the first respondent ineligible to participate in any future elections as a presidential candidate.
As we opted to show you, and I have in the studio Honorable Makebi Zulu, the lawyer or legal counsel who represented the former head of state, Dr. Edgar Lungu. You've gotten the position, legal counsel.
Exactly.
MC.
So let's start from this point of view.
Yeah.
The court is saying, for purposes of 2021, he was eligible. For purposes of 2026 and future elections, he's not. That defies all logic. They explained his eligibility in 2021 to say because there was a judgment that was subsisting that says that he was eligible, therefore his participation will not be questioned. But now you are telling us that a person who didn't qualify stood in the 2021 election, notwithstanding that there was a judgment that said he qualified. What does it make of that particular election? What does it make of the presidency of President Hakainde Hichilema? We are of the considered view that the court chose to merely say that we will not question that, because to question it would have meant that they need to go to the election of President Hakainde Hichilema. Because the moment you, the court, have said that this person is eligible, it means that you are party to an illegality. You, the court, sanctioned that illegality. When you sanction an illegality where you're saying the person who does not qualify should stand, what does it make of that election? Does it then become a free and fair election? The court should be able to pronounce itself. Was the election where you sanctioned a person who is not eligible to stand be considered a free and fair election? They should have gone to that extent. And they would have come to an inescapable conclusion that that election was not free and fair. And they are the ones to be blamed for that. So having revisited that decision, having vacated that decision, it therefore means that he was ineligible then. Having been ineligible, he should not have contested the elections. Now they're telling us there was an imposter on the ballot paper. What do you do to an election where there is an imposter on the ballot paper? Because you can't tell us that that election he was not eligible for future, he was eligible for future elections, he's ineligible. It doesn't make sense. It defies all logic. You have to explain it in a better way. The explanation to say that the law that subsisted at that particular time, or indeed the judgment that subsisted at that particular time, no matter how bad, still subsists, should be obeyed until it's vacated, flies in the very teeth of what has been going on. Look at this. The Bowman Lusambo case and
the
Malanji case. There was an order of the court staying that election. That order has never been vacated. To this day, that order has never been vacated. What did they do? ECZ went ahead and held that election. As we are talking, the Kawambwa seat for Honorable Chilangwa, there's an order staying the decision of ECZ to proceed with that election. And there are contempt proceedings that are currently ongoing in the High Court. And yet they are going on with that election. There was an election for council chairperson in Kawambwa itself, where Kawambwa was council chairperson. There was a stay in that matter. There was a stay. There still subsists a stay in that matter. But ECZ has gone ahead to hold that particular election. So you see the double standards that are being applied in all this, and critical issues not being addressed. Perhaps the court would do us a favor if they said, okay, we erred. That is what they're saying. 4 times, or the 3 times that we decided. I say 4 times because the last 2 cases were amalgamated and the decision came as one. Exactly. So I'm saying 4 times the court decided that this person is eligible. And having decided that he's eligible, the 5th time they're saying, no, he's not eligible. What guarantees us that in the next few years, should the face of the court change, that there will not be a different decision? Because
over the same
exactly. Because what they said is that no, Section 2 of Act Number 1 of 2016 was not considered. And we are saying that no, everything was considered, because all they have gotten is the dissenting judgment of Judge Mnarula in the Legal Resources Foundation case and made it the main judgment. There is nothing that has been reinvented in this particular matter. And they have gone further to do what they said should not be done. I will give you an example. When the case started, the petitioner stood up and said, we have raised certain grounds and certain prayers that we want the court to consider. And one of the prayers that we have raised is that we want the court to arrive at a decision that the decision in the Legal Resources Foundation case was arrived at per incuriam. Now, for the viewers out there that do not know what the meaning of per incuriam means means that it was arrived at by mistake or in ignorance of a law that subsisted. Okay.
Without proper
scrutiny. Exactly. So they are being invited to say these 4 cases, these 4 times, you arrived at your decision by mistake, right? And or in ignorance of Section 2 of Act Number 1 of 2016. That's exactly what they are saying. Then we stood up and said, no. Amongst their prayers in their petition, they have not included this particular position, that they want you to declare the last or the judgments that you passed last as having been passed per incuriam. The court agreed with us and said we will expunge it from the record and the court expunged that particular prayer from the record, meaning that all the parties were not to argue an issue that has to do with the matters having been arrived at per incuriam, but the gravamen of their decision that they have come up with is to say that we have been called upon to decide that the matter was arrived at per incuriam. And in discussing this matter of the client, he says, but we raised that issue, and they said, let it be expunged from the record. It was expunged from the record, meaning that we have not been heard on this particular matter of the decision having been arrived at per incuriam. If they had said it was part of the matter, we would have pushed and pushed and pushed to show that the decision was not arrived at per incuriam, because the decision, that of the court, the majority judgment, and that of the dissenting judge, Judge Mnalula, who dissented, formed part of one decision, meaning that everything was considered at that particular time. You can't say that this was arrived at in ignorance, because Judge Mnalula in a judgment says, these are my considerations. The majority said, we do not agree with you. And that stood to be the decision of the court. But what did we see during this case? We saw that those that looked at the case and decided that was eligible quickly were removed from the bench in the shortest possible time, the shortest the shortest trial, as it were, of judges and removal in the history of this country was for the 3 Constitutional Court judges. And we have no doubt in our minds that it was for purposes of securing such a judgment. We have no doubt whatsoever, because it is clear. The writing is on the wall, and it has been on the wall. Even from the time we raised the issue of the conflict of interest that was there, the time we raised a preliminary issue to say you have already decided this matter. In any case, the injustice that has been done in this matter is that when we raise the issue to say this matter is res judicata, that is to say that it was already decided at that particular time, the court should have told us, no, it has not already been decided.
Right.
So because it has not already been decided, or there are these new factors that have to be considered, we cannot say that the matter was already decided. Therefore, we will go ahead and hear this matter because there are new matters to be decided. Meaning that the respondent was then going to fashion the answer to respond to the issues that have been raised have been raised by the petitioner, to the extent that the matter would have properly been dealt with on the merits. Because as far as we're concerned, going through the whole case from the first to the end is that this matter has already been decided. You've decided it 4 times before. This is the 5th time it's coming before you. And they acknowledge that, yes, they have decided, and they're saying we have vacated the decisions that we made. They have vacated 4 decisions that they made for this particular one. What are the odds that they are right this time around and they were wrong the 4 times? What is it that we are creating for ourselves in the Constitutional Court? It means that we'll keep pushing the same matter over and over and over again until there's a different decision. I'll give you a typical example. When Judge Shilimi was appointed to the Constitutional Court, there was argument that he does not qualify to hold that position as Constitutional Court judge, because one of the requirements is that you have to be an expert, at least an experience in constitutional law and human rights. In his CV, the only attribution to human rights was that there was a module in his master's that had to do with international human rights. That is what was there. It's like me saying, the time I was at Ziali, yes, there's a component of accounts that I did. So would I be said to say I'm qualified, proficient in accountancy? Can I call myself an accountant? Can I say I have experience in accounts because I did that particular course to do with bookkeeping and accounts? I can't. And that was our argument which we took before court. So it means that Now, we can still go back and open that door and say, no. Last time, you arrived at this decision by mistake when you said that he's qualified. Look, it was only a module. It was only a subject that he did. That does not connote a qualification. I will go to court, and then they would have to sit down. They can't raise the issue of res judicata anymore, provided it's a different person that has gone to court. But we're saying it is not about there being a different person. It is about the same issue having been determined. It's not the person, but the issue that the court
is the subject at
hand.
Not a new person,
not a new person who has gone to, because even this new person shares the same interests as the other persons that have come before you.
Right.
That is the issue that we had presented to the court. This judgment is unfortunate because now it opens it up for further litigation on matters that are supposed to be closed. Even when the court itself says we are bound by our own decision. It was interesting to listen to the court and listening to them say the Constitutional Court, whereas the Supreme Court is given power by the Constitution to relook at its own decision. There is no express provision in our Constitution that gives us, the Constitutional Court, that power. They say that. Meaning that they're admitting that the very fact that the framers of the law chose to give the Supreme Court that power to revisit their decisions, and they did not give the Constitutional Court that power to revisit their decisions, it means they never intended to in the first place. They never intended that the Constitutional Court should be one that could revisit its own decision. But what have they done today? They have donated to themselves that power. And having donated to themselves that power, they went ahead and came to the decision that they did. A rather unfortunate decision, respected by a client, being a law-abiding citizen, knowing very well that this has been an agenda of this current administration to bar him from participating in the 2026 election. Because he is a very formidable candidate who is capable of unseating them. Look at the wind that has been blowing over the politics, the geopolitics. Donald Trump was president. He left office. He's back now. In Ghana, the former president is back now. In Botswana, the former president, the person that the former president supported, has gotten back. So you have all these politics that are going on, and I'm sure President Hakainde Hichilema told himself, I can't handle this. I can't deal with this. Hence the firing of those judges that participated in this particular matter.
You are now insinuating.
I'm not insinuating. This is a matter of fact. Come on, everybody knows and says this for what it is, that what happened was clear and sheer mingalato that was there. See, if we're going to look at the issue of those particular judges and how they were removed, and how that the decision and that the JCC came up with, to say that, as a matter of fact, these are not qualified. You see, they overstep their power, as it were, because they have no power to do with whether or not a judge is qualified. But they went to that extent. And what does that tell you? It's on that basis that they were removed. So, are we saying that the Judicial Complaints Commission deals with the issue of qualification of judges? The issue of qualification of judges is a threshold issue before they're even put into office, before they're even ratified. It's a threshold issue. It is, they undergo scrutiny and until there is satisfaction that they are duly qualified. That is the parliamentary procedure. It is not a matter for the Judicial Complaints Commission. Now, even talking about the issue of the Judicial Complaints Commission, you see, we have this monster that we have created that has no legislation to back it up. The predecessor to the Judicial Complaints Commission was the Judicial Complaints Authority. It was investigative in nature, meaning that it would investigate a misconduct of a judge, then make recommendations to the president, who appoints a tribunal appoints a tribunal to hear and determine. Now, that tribunal is the one that has the judicial powers of some sort. So now, the Judicial Complaints Commission is carrying out some form of quasi-judicial function. There is no legislation that tells you what the quorum should be. There is no legislation that tells you how they should conduct their business, though the Constitution says that they operate in a manner that will be prescribed. They can't rely on the procedures for the Judicial Complaints Authority because that was investigative in nature. They have to come up with a new statute. We need Parliament to promulgate a new law because that's what the Constitution says, that they'll promulgate a new law that they will be dealing with, because now there's nothing that regulates their procedure. Right. That's why you are able to see the abuse that has been going on there. Now, should we then say that after change of government, as it were, or after change of faces in certain offices, someone comes and says, as a matter of fact, what you did when you fired these 7 judges, including the DPP, was not backed by any law? What would the decision of the court be? What is it that the court is going to say? So we have a lot of things that are going on, that have been going on, where matters are being reopened. The issue of the judges, a matter that was determined but still reopened and a different decision has been arrived at. The matter of Edgar Lungu, a matter that was determined, closed, and has been reopened, and now there's a different decision. Should we, as a country, say that we will have different decisions with each and every administration that comes?
Has the court departed from its earlier decision? In a layman's language,
the court,
and I wanted to distinguish revealing the decision and departing from the area or a decision.
See,
what are the distinctions there?
I do not want us to delve into semantics of revision and departing.
This is what was in court.
So, that's exactly what I'm trying to explain. When you revisit a judgment, you are going to look at the propriety of that particular judgment.
Right.
The manner in which it was arrived at, the reasoning behind it.
Right.
And after revisiting it, if you are of the view that you were wrong, you depart from it.
Right.
You set it aside and come up with a new one. So you can say, we have not revisited, we have not reviewed the decision, we are simply departed from it. What's that? Because before you depart from it, you must state why you're going to depart from it, give reasons for departing from it, tell us what's wrong with it, then say, because we were wrong in this particular decision, we are putting it aside. Now, this country has been brought on its knees right now because of the supposedly wrong decision of the Constitutional Court. We are in this mess because of the Constitutional Court. Now, what should we say about you, the Constitutional Court, that misled this country to believe that he was eligible when in fact not? You did not only do it once, you did it twice. Not even twice, 3 times. 4 times you kept telling us he is eligible. If we had known, if you had told us the very first time that he was not eligible, this could have been avoided. It could have been avoided, and who knows, if a different candidate was floated by the Patriotic Front Party, maybe that candidate would have won. If President Edgar Lungu did not stand, maybe Fred Membe would have won. He could have benefited from his not standing. Maybe Harry Kalaba would have won. Maybe the others would have won. And it is for that reason that we're saying, now that you're saying that this person participated because of your error does not make the election free and fair. Your error was to the as to the participation. The effect is that the election was not free and fair. You can't say that just because a court said that he could stand, then the election became free and fair. You've already told us that his standing was unconstitutional. It breached the Constitution. So he cannot be said to have been eligible then and not eligible for future election. You are confusing everyone. As a matter of fact, you are confusing people out there who are saying these two can't be in the same sentence. Eligible and not eligible at the same time. You can't. Suppose President Edgar Lungu won that election. He would be in office now.
Serving his second term or third term?
Well, because their interpretation, which they gave us, is that for purposes of the Constitution, anything less than 3 years cannot be deemed to be a term. Okay? Now they're explaining to us to say the effect of Section 2 means that it preserved the repealed Section 35. When you say repealed, you're saying it no longer exists. So how do you preserve something that no longer exists? It defies all logic. It defies. It was repealed. It's not there. It's just not there anymore. But the court, in the earlier decisions that they have departed from, went further and said, transitional period. What do you do in the event that there is no match that has been set to cover for the transitional provisions? They even went further and quoted the renowned writer Benyon on statutory interpretation and gave a reasoned judgment as to why that was not to be considered a term. That is what they did. They went further. But I was hoping that they would be dealing with those issues that were dealt with in that particular case. I was hoping that they would be discounting them one by one as to why they were wrong. But all they have done is get the dissenting judgment of Judge Mnalula, who's the judge president of this court, hook, line, and sinker, adopt it as the new judgment of the court. By the way, in the Danpule case, the court was unanimous, including Judge Mnalula herself, that President Edgar Lungu was eligible. In the Bambi Kapalasa case, it was the same. It was until the Legal Resources Foundation case that she departed from that decision. So, in looking at all this, we're wondering what exactly is going on. What exactly is going on? Are you saying that you have been incompetent all these 4 times in the manner in which you have interpreted the Constitution, and you are right this time around? Where has this sudden competence come from?
You call it competence now.
Yes. Why have you become competent
more
now
capable
to be able to understand the law, which you ignored previously? Because we are not going to say this is a different constitutional court, because it's the same court.
Should we say it's a different constitutional court because it's operating under a different regime or government?
That is what they are telling us. That provided you are going to get judges that are going to agree with your particular position, then each regime should be able to appoint judges that are going to agree with their positions. Because remember, this is the position that is was being held by the UPND. You see that? And this matter has been brought up in this time around with the events leading to this being statements from government, statements from the Minister of Justice then, Haimbe, and saying we are going to go to court, we are going to challenge this, and Michelo is on the scene, a surrogate of the UPND, being used to fight, to bring up this agenda. The face of the court.
A surrogate of the UPND, or is a mere citizen who has got the rights to, press certain matters before the court if he's not clear. Listen, and that's what he has just done.
He has done that.
Yeah.
But the question is, why has the court deemed itself to have been incompetent or erred 4 times before, and they are correct this time around? Why are they telling us he was eligible in 2021, he's not eligible now? So we are going to focus on this judgment to block him from standing in the next election. Are you telling us that we are free to come back to court using a different person to challenge this decision and tell you that you arrived at that decision in error? Should we do that? They have opened the door and they're saying it's okay, you can do it. So it means that matters will not be closing. They'll be going on in perpetuity just like that.
I want us to play a video of the former President Dr. Edgar Lungu. Of course, prior to this judgment, actually did cast a number of aspersions regarding what he alleged that was being orchestrated in the background. So we'll listen to this video, and later on I will engage in counsel Makebi. Let's hear.
And women, fellow Zambians, I have chosen to make my remarks on this matter because of their importance to the life and well-being of our country. You are aware that recently there has been legal petitions against my eligibility to stand as a presidential candidate in both 2021 and the future. This matter has been settled by the Constitutional Court. The reopening of what was settled remains illegal and a clear act of lawlessness. It is now common knowledge that the petitioners are surrogates of State House and remove those perceived to have vested interests in the case. My hope and prayers are that there will be respect accorded to my application currently before the court to help restore confidence in the courts and the judiciary. The recent events where professionals have been removed and punished for doing a professional job makes a very sad turn of events. I have in mind the unconstitutional removal and harassment of the former Director of Public Prosecutions, Ms. Lilian Flatashawa Sioni, the Registrar of Societies, Tandiwe Piri Muhende, and the recent suspension of 3 constitutional judges, among others. All the complaints against the judges were comprehensively dealt with. We see that the matter has been, without cause or justification, reopened, and the judges now stand suspended. These developments are very serious and are undermining the rule of law and democracy in our land. The scheme to undermine the 2026 elections. It has become very evident that schemes designed to undermine the 2026 presidential and general elections have been heightened. From secret issuance of NRCs or national registration cards.
All right, those are the sentiments shared by the former president, Mr. Edgar Lungu. Of course, that was prior to the judgment that has been delivered as of today. I have in the studio Honorable Makebi Zulu, counsel to the former president. So from the word go, seemingly you doubted the credibility of the court judges as well as the system in general. It's like you had given up already.
As my son would say, where's the lie? In the statement that he said, where's the lie? Because everything that he said, everything that he suspected would happen, has happened. Because indeed this is a matter that was settled. Indeed this is a matter that has been relitigated. He's been dragged to court over and over and over and over again until there's this different decision. So if we're going to look at it for what it is, and how that the judiciary has been used over time to endorse the will and the whims and caprices of this administration, you come to an inescapable conclusion that there is a high probability, or indeed a matter of fact, that there is something that needs to be done. You need a judiciary that is predictable. Is it predictable? I think it has become unpredictable because people are not going to go home and settle to say, this judgment that I have, I can rely on it. People will always be on their toes and say, someone will wake up tomorrow and go to court and I may not have this judgment anymore. There must be finality to matters. That's the principle of res judicata. Finality to matters, and that the same person cannot be dragged to court over and over and over again for purposes of achieving a different result. Now, in the very court, in the case of Legal Resources Foundation, says we frown upon this idea of you bringing this matter over and over and over again to get a different result. We have told you he's eligible. Why are you coming back to us? They scolded State Counsel Sangwa. Why do you keep coming back when we've already told you? This is unbecoming. That's what they told. Now, are they saying, no, we apologize, State Counsel Sangwa, we were wrong, you were right, this is the position. Now, they are challenging a losing candidate. And this is a matter that was brought to their attention. We have no procedure for challenging a losing candidate. And the procedure for challenging a nomination, as it were, is that you wait for the person to be nominated.
Yeah.
After the person has been nominated, you have 7 days to file your petition.
That's under Article 52.
Exactly. You file your petition and the court will deal with the matter. And at the end of it, or if the court finds that the person is not eligible, then the court will say, you are not eligible, file all over again. Meaning that all the other parties will file, a party that is disadvantaged will replace.
Right.
Yeah. Okay. Now the Danpule case, in dealing with the eligibility case, they went to court for an interpretation. The Bampika Palasa case went to court for an interpretation. The Legal Resources Foundation case is a proper case that challenged the court because it went at the time a nomination was filed. Okay? Because that is the window period that is open for purposes of challenging a nomination. Now we had a whole petition out of time, and we told the court, these people can't even bring this matter now. Perhaps it would have been neater if they waited until Edgar Lungu files his nomination. And then you deal with it at that particular time.
Right.
So no party is disadvantaged. Then you would have an opportunity to vacate your decision if at all you will, because you'll be dealing with it from different facts. Now these are the same facts that are being brought to you. This is the 5th time these same facts are being brought to you and asking you to come up with a different decision. We told them you can't do this. And the reasoning that they've given us for arriving at their decision and vacating all these other decisions that they've made, they have not given us. We thought they would give us special circumstances, special issues that have a reason now that would justify that. There are no special circumstances that were stated. There is nothing that was not said that has been said now to warrant a change. The only change that has been there is the faces of the court and the Attorney General, who has shifted.
Should we cite perhaps political interference in these, in the judiciary in the similar manner, which you are, insinuating that there could have been some forms of evil machinations behind? In the similar manner, the former head of state also was insinuating that he was aware that the system was being manipulated in the background to bar him from contesting. Can we, from the executive, can we cite that maybe under the PF administration, under ECL himself, there was also some similar forms of evil machinations?
You see,
which maybe led or could have led those judges to maintain that position?
The legal fraternity is very small, and we interact. Lawyers are judges. and it's lawyers who eventually become judges. So before they're judges, we interact. When they become judges, we still interact. But I will tell you that as a matter of fact, the judges that are honest enough to open up to you will tell you that the manner of interference that they're experiencing now is untold. They have never experienced such kind of matters. Now, it is not far from fetch that a person could say there has been manipulation because of the manner that the courts themselves have acted in certain matters. This matter is one that opens the door wide, that you can draw all sorts of inferences that should be drawn. From the time it started, and if at all there was that realization that this matter is of public interest, it should have been from the start that this case should have been televised. So that you carry the audience with you, you carry the citizens with you.
I was coming to that.
In the arguments that are being presented before the court. Because even in listening to the judgment, there are a lot of things that were said that have not been captured. I will give you a very, very good example. You know, when the matter started, and Counsel Mono was addressing the court. If I may be allowed to read verbatim what was going on in court.
Go ahead.
He was addressing the court and saying the petitioner requests the following. He says, he requests that you grant him a declaration of the first respondent's participation in the August 2021 presidential elections was unconstitutional. He prays for a declaration that the first respondent is not eligible to contest the presidential election under Zambia's 2016 constitution, which is the current one, as read together with the now repealed 1991 constitution as amended. He further prays for a declaration that Article 106 of the 2016 constitution does not and did not apply to all the first respondents' first presidential term, and he further prays for a declaration that the first respondent is not eligible to contest a third presidential term. This is the part that I'm coming to. It says, lastly, he prays for declaration that the case of Legal Resources Foundation Limited and two others versus Edgar Lungu and the Attorney General delivered by this court in 2021 be rendered per incuriam. So when he mentioned this, I stood up and this is what I told the court. I started by saying, perhaps if I may, the last question that my colleague has raised does not appear on their petition to say that judgment that was rendered in the Legal Resources Foundation case be rendered per incuriam. That's not one of the prayers that has been sought, unless there was an amendment which we are not aware of. Justice Munalula turns to Mr. Mono and says, Mr. Mono? Then Mr. Mono responds and says, much obliged. A reading of the petitioner's skeleton arguments on page 57 of the record of proceedings clearly outlines that declaration will be sought. Much obliged. I responded and said, if I may, my ladies and my lords, it is not in the petition. The argument may have a forest of words, but for as long as it is not in the petition, it does not apply. Mr. Zimba augmented me. Then this was the ruling of the court. The decision of the majority, the reference made and additional relief contained in the statements of arguments be expunged from the record. So I will end there. The court decides to expunge the prayer that the decision in the Legal Resources Foundation case be rendered to have been given per incuriam, meaning that we were all precluded from arguing the issue that the decision in the Legal Resources
Right.
Foundation case was arrived at per incuriam. Now, today's judgment, page 52, paragraph 8.5, on that point. But that is a point which they expunged from the record. That is the point that they said, you have not raised this issue, your pleadings do not contain this issue, you can't talk about it. Because the idea of you stating what you want is so that the other party knows in advance what you're bringing before the other court, and they're able to put up their defense. Now the court comes, tells us that will not be considered. The decision of the majority of the court is that this issue of rendering the Legal Resources Foundation case as having been arrived at per incuriam will not be debated. And then in paragraph 8.50 they're saying, we have been invited to look at our previous decision in the Legal Resources Foundation case and say that it was arrived at per incuriam. And they do that. What does that tell you? It tells you that President Edgar Lungu then was not given an opportunity to be heard on that question. If the court at that stage, when that objection was raised, said that no, we will include that, we will amend it ourselves and include that so that we are able to holistically look at it, then us as his lawyers, together with himself, with our client, we're going to sit down and address that question fully so that the court appreciates what our thinking is. So in this particular case, we have not been properly dealt with in this regard. As a matter of fact, this matter arose at some point after this, where Judge Msaluke asked the Solicitor General to say, your colleagues have objected, and they say that this matter or this prayer was not included. What do you say to that? The Solicitor General gave his opinion. I stood up and asked the court, maybe we should be heard on this matter, on this question that you have asked our colleagues. That the very fact that this matter has not been pleaded, it is not one of the prayers, and it is being pushed. We would like to be heard. The judge says, no, I wanted my answer and I've gotten it. So you've gotten your answer, and we are saying we want to be heard because you have an answer. You have not heard what our position is. So the verbatim will show you that at any given time when the issue of per incuriam came in, we objected, the court agreed with us, even when the court asked the question and we wanted to be heard on that particular question, the court refused to hear us. And they come to a decision to say, we have been invited to come to a decision that the Legal Resources Foundation case was arrived at per incuriam. That is the place where we find ourselves at. That is the reason we're saying our client has been very magnanimous, even in his response to this. He has issued a very measured statement saying we will be going to Plan B. But in any event, it is important that the court should be able to put certain things in perspective. It is important that the court should be able to address certain things that have been left hanging. It is important that the court should be able to tell us what exactly is the effect of that particular election. Did they arrive at the fact that his participation is okay for purposes of preserving the presidency of Hakainde Hichilema? Because if the net effect of participation of a person who is not qualified is that the election was not free and fair, then we should be calling for another election. Then we should be calling for another election. I would have thought that they would have told us that because of lapse of time, the remedy for dissolution or the remedy for cancellation of the election is no longer there. They would be correct because that challenge is time bound, meaning that they should have been saying that this matter should not have been brought because we no longer have jurisdiction. We only assume jurisdiction within a specific period of time. You have brought it now and we don't have that jurisdiction. And like using this to purportedly want to review and discard of certain decisions when issue of jurisdiction has been raised and certain questions have not been answered, and not going to the very bottom of it to say, because a person who was not qualified, we allowed that person to participate. That did not in any way mean that the election then became free and fair. The election was not free and fair because by our mistake, we allowed a person that did not qualify to be there. And therefore, we declare it a nullity. We call for a fresh election. Of course.
Which was going to be costly if that happened.
It is not about whether or not it's costly. It's about, are you doing the right thing? Right. There's a certain statement, a phrase that was going to say, in the interest of justice. Were they doing it in the interest of justice? Because if they were doing it in the interest of justice, that injustice that they caused must be addressed. And it must be addressed with the same interest of justice that it deserves. You can't then say, in the interest of justice, he will not participate, and in the interest of justice, he participated. It can't be. It can be both ways. That issue, you have to be blind to everything else, blind to the fact that President Hakainde Hichilema is in office, blind to everything else that has gone on, and say, what is the actual position? And you deal with it as it is. That's what should have been done.
I'll ask you, I'll find out from you, counsel, what is that plan B from your client? But before that, let us also watch another video coming from the government spokesperson, Honorable Cornelius Mwetwa, who has given a comment in regards to the ruling around the former head of state. Let's watch this video of Honorable Mwetwa.
The law and no other considerations or persuasions. That is to say, former President Edgar Lungu has not been barred or blocked from contesting 2026 general elections or any other beyond. Rather, it is the fact that he is ineligible and does not qualify. I'd like to clarify that this judgment was not about blocking former President Lungu. It was not about barring him contesting future elections. It was about resolving the question of eligibility, to which it was his eligibility, and the courts have pronounced themselves. Therefore, assertions that President Hakainde Hichilema, State House, or any other government functionary has had a hand in this judgment have got no merit or basis whatsoever. They are and must be treated as such to be mere political rhetoric and all well-meaning Zambians and beyond should dismiss such kind of assertions with the desire
to give you the chance as well to call in the studio. The number is right on your screens. I have in the studio Honorable Makebi Zulu, the lawyer to the former president. We are actually in the dying minutes of the program, but maybe you would want to react to what Honorable Mwetwa has clarified.
That was not a clarification.
What was it?
That is an excited member of the UPND, a spokesperson of the government, who's excited and thinking that the fortunes for 2026 have been redeemed. But that's not the case. Make no mistake about it. President Edgar Lungu is going to come back, and is going to come back strong. He has made it very clear that it is not about him. It is not about him. In his statement, he has made it, don't make a mistake to think this is about Edgar Lungu. This is about the democracy of this nation. Whether by himself or any other person, President Edgar Lungu is coming back, and is coming back strong. And in 2026, the chickens will come home to roost and say, when you promised that you deliver on fertilizers, you failed to deliver on the issue of fertilizers. When you promised on the issue of fuel, you failed to deliver on the issue of fuel. When you promised on the issue of milling meal, you failed to deliver on this promise. When you promised on the issue of a better livelihood, living standards for the Zambians, you renegated on the, you reneged on your promise, and it has not been so. When you told us that load shedding had ended, it has not ended. Those are the things that Zambians are looking at. And President Edgar Lungu, whether they like it or not, is going to be a determining factor for 2026 election. Whether by himself, should Plan B succeed,